The next case is State of Ohio versus Dezmon Lawrence. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. Please let me know if you'll be reserving time because I will be keeping track of the time. The arguments are being recorded. When you present your argument, please keep your voice up, remain behind the podium, and also introduce yourself. You should not use the name of children, minors, or victims in your arguments. Please refer to them by initials or terms like the child. We've read your briefs and are prepared to proceed when you are.
Thank you. Good morning. I'd like to reserve 5 minutes for rebuttal, Your Honors. Attorney John Kopasakis, 0090784, on behalf of Dezmon Lawrence. Your Honors, this matter was initially indicted in the County of Lorain for a series of actions that occurred that began in the County of Lorain and terminated in the County of Erie County. Mr. Lawrence was charged both in Lorain County and Erie County. In both indictments, Mr. Lawrence was charged for kidnapping and felonious assault. In the Lorain County indictment, he was charged for rape. The majority of the instances happened in Erie County. There was one day of instance that occurred in Lorain County. Erie County decided in their charging documents to only charge Mr. Lawrence for 1 day of the alleged incidences as opposed to all 3 days. But Lorain County decided to charge the entire band of the events. We believe that, and the Erie County case did proceed to trial first. There was a series of acquittals and convictions in that matter, and Mr. Lawrence is serving time for the Erie County charge. In the meantime, his Lorain County charges are still pending.
Counsel, I'm confused by what you just said. You said that Lorain County chose to charge for everything, including what was already prosecuted in Erie County?
Yes.
Really? Could you be more specific?
Sure. So Lorain County charges Mr. Lawrence for instances that occurred from December 19th, 2021 through the 21st of 2021. Erie County only charges Mr. Lawrence for, I apologize, one moment, everything that occurred on December 20th. So Erie County says, we are filing an indictment, it is only for December 20th, the kidnapping and charges. Lorain County has covered that entire bandwidth. And in those charges include kidnappings and the events that occurred in both counties.
Well, even if you have the same dates involved, there's an additional charge of rape, right?
Yes.
That doesn't match the elements of any of these other charges.
Yes.
There's things you have to prove with rape that don't involve kidnapping.
Correct.
So how do you have an argument here on that?
The kidnapping charge, has a sexual motivation, and the entire charge itself is fleshed out in the Erie County case. Further, the purposes of the, I have to apologize, I can't remember, 25CA012254 is to bring everything together into one indictment for purposes of judicial economy. The purposes of RC 2901.12 is to have everything move in a more efficient manner to avoid a double prosecution situation. It keeps things cleaner, it keeps things more efficient.
Counsel, isn't that a permissive language in 2901.12H? Doesn't it say when an offender, as part of the course of criminal conduct, commits offense in different jurisdictions, the offender may be tried?
It is permissive.
All of these offenses?
It is permissive, but there is a strong push towards bringing and unifying all these charges together.
What is that? What is that push? Where do I find that push?
Stateview Walker 6th District would state that splitting venue is permitted so long as it doesn't prejudice the individual. The Minor Court still noted that Nervin seems to emphasize the prosecutor cannot play dirty pool when the person is in a diversion program. The case law cited gives us that impression that, you know, when you're splitting up jurisdictions, when you're splitting up venues like this, it creates a broader problem where an individual can basically receive two different sentences, two different outcomes, two different verdicts in that situation. You know, in this situation, Mr. Lawrence would be punished twice. He'd go through the entire criminal proceeding in Erie County, he'd receive a sentence from Erie County, and whatever happens in Erie County, you know, he would then receive an additional punishment, an additional penalty, an additional case. He could have a completely different outcome in Lorain County once the venues have been split like that. It incurs additional charges, costs, and it's just patently unfair. You know, he has to do everything twice for what is essentially a series of criminal conduct that could be or should be brought together in one location. Again, the instances are broken up only for the purposes of charging Mr. Lawrence twice. There's no judicial benefit or there is no broader public benefit for having this in two different areas. We also believe that, going back to the kidnapping charges and first argument, that these are clearly duplicative. He's been charged with kidnapping in Lorain County for what is a span of days, and then he's being charged for one of those days that is already covered in Lorain County in Erie County, and that matter is adjudicated and is brought to a resolution. We believe because it is duplicative that it's double jeopardy. If it were the other way around, if Mr. Lawrence had completed his case here and then the matter in Erie County continued, it would be clearly double jeopardy because the date that was covered in the indictment in Erie County would have been covered here already.
Is that a presumption though? If you have a day-long period, there has to be an alleged act. I mean, you could have multiple, say if you're charged with felonious assault in two jurisdictions.
I'm sorry, my hearing is atrocious.
Say you're charged with felonious, say something happened over the course of a day or two, and you're charged with felonious assault multiple times among jurisdictions, there could be alleged conduct, though, involved with each one of those that could make the offense, right? So I guess the only way you'd be able to say it's double jeopardy is if it's exactly the same conduct.
I think the case law states that there needs to be separate animuses for each of the alleged conducts. Kidnapping is not necessarily an action that can be broken up and such, unless the kidnapping ended at some point and then started again at another point. It's not like a beating or a drug deal where once that beating is terminated, another beating starts. In this situation, the victim in this matter has been taken over by Mr. Lawrence, and that kidnapping does not end until the 21st in Erie County, which is covered in the Lorain County indictment. So I don't believe that would be sufficient enough to break it up so that we have individual instances that can be charged on individual days. Are there any other questions? Thank you.
Good morning, Your Honors. Spencer Lepwitz, I'm after the state. Normally I wouldn't do this, but I want to begin with a clear overview of the facts as they're alleged. And I think this goes to your question, Judge Sutton, about the dates. It is alleged that on December 18th of 2021, Mr. Lawrence did kidnap the victim, AB, from Elyria and take her to a place in Erie County, namely the Wolf Inn in Bergens. He didn't kidnap her on the 18th and immediately take her to Wolf Inn. It's alleged he took her from one spot in Lorain County to another spot in Lorain County, where on the 19th is alleged that while in Lorain County, he did rape AB. And then after that, on the 20th, he took her to Erie County, and that is where the charge of kidnapping, abduction, and assault, felonious assault, arise out of on December 20th in Erie County. They are separate, distinct acts with separate, distinct animuses, and they do not, for that reason, fall into the double jeopardy overview. Double jeopardy, according to Blockburger, requires that the same act or transaction is a violation of the statute. These are different acts occurring at different times in different places. Simply because the indictment covers December 18th to December 21st doesn't mean that the December 20th kidnapping nulls or violates or placed him in jeopardy twice for the acts that occurred in Lorain County. I think if you look at the transcript of the trial that occurred, the basis for the kidnapping in Perkins Township in Erie County was taking the victim from the hotel room, placing her into his car, refusing to let her leave his car, and then I think there was an assault issue as well with that at that point in time. Those are different than what happened in Lorain County. For that reason alone, there's no double jeopardy issue. And I think that goes to the first assignment of error the defendant raised. He also additionally raised the second assignment of error, and it seems to be, as the state understands it, the second assignment of error is that because these acts were a continuous chain of criminal events, they all need to be prosecuted at one time in one county, and that simply is not correct. It's not correct based on 2901.12H, which is, as you point out, Judge Sutton, permissive. The state may, or the offender may be tried for all those offenses in any jurisdiction, but they're not required to. The state isn't required to bring all those charges in a single jurisdiction. I think that we see that in the case that is directly analogous and directly on point to this one, State v. Cervantes, when the defendant assaulted his victim in multiple counties, attempted to murder his victim in one county, kidnapped her in one county, and was tried and convicted for those offenses in each county where they occurred. I think in this case it was Wood and Henry. At that point, the 6th District said, no, it's fine for when there's a continuous course of conduct for the state to bring the offenses that happened in one county in that county and the offenses that happened in the other county in that county. You don't need to combine them. It doesn't violate double jeopardy to try them separately, so long as they are different acts. That was held up by the 12th District in State v. Weigerman, by the U.S. Supreme Court in U.S. v. Dixon, right? The government, and according here from Weigerman, the government is entirely free to bring this prosecution separately and can win convictions in both, as long as separate prosecutions do not violate Blockburger. They don't violate Blockburger here. There's no same act. I don't quite know what else to say on this. Are there any questions for the court? And for that, the state will rest. Thank you.
You'll have a full 5 minutes.
Thank you, Your Honor. Again, I would stress that at no point is there any break in Mr. Lawrence's kidnapping of the alleged victim in this matter. There is no allegations that she ever escaped until the end of the incident, the 21st. There are no allegations that he ever lets her go or does not entirely have possession or control of the individual against her will. I think that shows a continuous animus throughout the entire proceeding.
What about that rape charge?
I would still stress that the idea behind RC 290112 is that the The charge itself needs to proceed with the actual underlying case. If there is a new animus, then I could see or understand a secondary charge, but again, it's the same thing going from location to location. As such, we believe that Mr. Lawrence's cases have already been adjudicated in the Erie County courts, that this matter should be dismissed for double jeopardy purposes. Are there any other questions? Thank you.
Thank you both for your presentations. The court will take this matter under advisement and issue a ruling in due course. The clerk of courts will mail you a copy of the decision on the day it's released. Also, the opinions are posted on the Ohio Supreme Court website. Thank you again.
Thank you, guys.